Good afternoon. Today is the 6th of November 2016 and today we're having a lecture series from Karen Harding Law. I'm Karen Harding here in Auckland, New Zealand, and reviewing a book that I have drafted. This is from the draft of the book from the 19th of February 2014, and we're discussing in this chapter Preventative Law and looking at the subchapter of the origins of preventative law. The terminology of preventative law, PL, borrows heavily from medical concepts, drawing on the idea that health is best secured while the patient is still healthy and can attend regular medical checkups. Accordingly, the time to see an attorney or a lawyer such as myself is when you're legally healthy, certainly before the event of litigation and prior to the time the legal trouble occurs. Of course, that may only be, for example, if you know you're going to get your 100 demerit points coming up and you want to get in advance a limited licence application, because otherwise you would be coming to see me in relation to criminal law before you did the crime. We'd probably advise you not to do the crime. So this is perhaps a more general thing applying to a range of other different kinds of law. So under preventative law, the lawyer is like a doctor and is uniquely placed to detect early symptoms of legal trouble, which are really self-evident to the client. It puts the lawyer in the role of taking the legal initiative. I'm a criminal defence lawyer, so I suppose if you were thinking about doing something and you did think you needed to get advice on it, you perhaps come and see me first so I could point out to you whether it was illegal or not. And also the same with perhaps taking on some other issues. Preventative law is prevention-orientated lawyering. It's based on the proposition that avoiding litigation will enhance client satisfaction. Preventative law is both proactive by seeking to enhance the client's position and defensive in seeking to shield clients from anticipated legal risks. Preventative law complements therapeutic jurisprudence as part of an integrated legal approach. The combination of preventative law, therapeutic jurisprudence and holistic law have the potential to provide an integrated and comprehensive and enduring solution to a client's legal problems and provide a means to address a client's connected non-legal issues. Prevention requires foresight and planning on behalf of lawyers to limit potential legal problems. It requires a forward-thinking mentality rather than a reactive approach. Solutional thinking is reactive and resource-based, representative of a rewind mentality. Preventative thinking is proactive and systems-based, a fast-forward mentality. A preventative law practitioner deals with hot facts instead of cold facts. The traditional practice of law deals in cold facts that are created by the parties, reenacted as testimony and recorded in a trial transcript. These facts are fixed historical and are therefore considered cold facts, whereas hot facts are live, alterable and current. So I guess in that respect, if we talk about preventative law, you're coming to see your lawyer really before your legal problems occur, perhaps when you're thinking of changing something. So maybe you want to change your will, so you want to come in and talk to your lawyer about what the consequences of that would be. If you're avoiding a whole lot of litigation perhaps after your death, that might not concern you at the time you're alive, but certainly eats up your estate and it's not really very useful in the end and causes a lot of problems. And maybe you're going to set up a business and you want to get advice on that. Maybe you've got some family issues and you're thinking about what to do about that in relation to custody access, marriage breakup, getting together, perhaps getting a prenuptial agreement before you get married and start living together, a whole range of legal issues. And of course, as a criminal defence lawyer like me and a traffic lawyer, if you're going to engage in some criminal offending, it would be best you don't do it. And if you're not sure if what you're going to do is legal or not, you should come and get some legal advice on it. Also, an employment situation, you're entitled to get legal advice on your employment contract before you start. So, for example, if you're working in another country, you need to be sure that you're going to be paid at least the minimum New Zealand wage. So you want to check with perhaps a lawyer in New Zealand, or at least do some research on what the minimum wage is so you know what you're getting into. So those are some advice I have on that, and I hope you found that helpful.